Do you believe she has a rational as well as a factual understanding of the charges against her?
I do, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been?
Quick legal note: deferred adjudication means the judge is basically hitting pause on your conviction. You're not guilty yet, but if you mess up even once, the court can slam you with the full sentence. So when the judge says 10 years in prison, that's not a bluff, it's a very real sword hanging over your head.
Represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at a $1,500 fine. The state recommends deferred adjudication. Did you understand that to be the plea?
Yes.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in both places?
Yes, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 4 years. There be a TAP evaluation and 180 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
And in Exhibit 1 and attachments, Your Honor.
No
Any-
objection.
All right, state, you may be excused.
Thank you, Your Honor.
Did you review the waiver and consent to stipulations of testimony and stipulations with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places?
Yes, I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, I've spoken to the state about addressing the fine and community service. My client has a special needs client or a special needs child who's 7 years old, autism, nonverbal. That takes up a significant amount of her time. She also has a 3-year-old who's in the Head Start program. And she owns a small business where she does baking. We would like any help we can have on the fine and community service, Your Honor, considering the demands of her time with her child.
All right. Why were you driving 80 miles per hour?
I wasn't driving.
Oh, no.
No.
Oh, somebody, I mean, if somebody else is driving, because they're saying you were evading in a vehicle. So if you want a jury trial, we'll give you a jury trial.
Hold up, 80 miles per hour? That's double the limit. And this comes right after her attorney pleads for leniency because she's caring for a special needs child. What do you think? Should the judge show compassion, or is reckless driving at this level too serious to overlook?
State? She says she wasn't driving. Part of evading arrest, detention in a vehicle is you're the driver. According to the police report, it states that she was driving.
Yes, Judge, we also have a dash cam video of it, of her getting out of the driver's seat.
All right. They say there's a dash cam video of you getting out of the driver's seat.
I was just a bit angry that night.
Then why are you pretending as though you were not driving?
I'm nervous.
No, nervousness doesn't make you be dishonest. You told me that you were not driving. And now the state says they have a dash cam video of you actually getting out of the driver's seat.
Mhm.
So why were you driving 80 miles per hour?
I was just on edge that night. And I
Why?
was trying to get home.
Why?
Me and my boyfriend at the time were fighting.
And is this Eduardo Ramirez?
Yes.
All right. So what time of the night was this?
I don't really remember, to be honest with you. I really don't remember.
Was it dark outside?
It was. It was dark.
All right. Were your children in the vehicle with you?
No, ma'am.
So who was taking care of your children?
My parents.
All right. So now we know the real people who are taking care of the children are her parents. She's just still living her best life with her new boyfriend.
That's not true.
Okay. So you're evading 80 miles per hour in a vehicle. Your attorney says you have a special needs child plus you have a young child, and you're out for a joyride with Eduardo Ramirez. And you're speeding going 80 miles per hour in a 40-mile-per-hour zone. So I think counsel, she has
This is where Judge Fleischer's tone shifts. She's done being lenient. When the defense paints the picture of a struggling mom, the judge sees someone whose parents are already doing the heavy lifting. This moment highlights a key courtroom reality. Judges don't just listen to words, they read between the lines.
time to do the community service because I think her parents are doing more than what's being presented to me. So do your parents babysit?
Sometimes, yes.
While you're running your bakery, where are you running your bakery from?
At home.
All right, that's your house, not their house?
It's their house.
All right, so her parents are doing the heavy lifting. All right, it's going to be a $1,500 fine. That's going to be probated, 4 years deferred adjudication, 180 hours of community service restitution. I'm going to order parenting classes. Once she completes parenting classes, community service hours will be deemed satisfied. So do you have all of your DBAs in order, or you're just baking from your home and when people want a cake or?
No, it's registered with the county.
All right. There's going to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. If you're drug tested today, what will the results be?
Negative.
There's going to be field visits 1 time per month for 6 months, defensive driving course. And there's to be no contact with Eduardo Ramirez.
Yeah, the only issue with that is that as of now is her husband. I believe they're going through a divorce, but there might be the need for contact to resolve that divorce.
All right, no contact with Eduardo Ramirez. The only exception is for court.
That works.
Is
Thank
there
you, Judge.
anything else?
Nothing further on.
Probation, is there anything else she needs? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, I did.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. Your children have to come first. Well, not always, because you would not have been going 80 miles per hour, whether you're upset with your boyfriend / husband or not, because anybody could have been killed. And police don't like when you're going 80 miles per hour and they tell you to pull over and you don't. You could have just been another person on the news that's dead with your parents doing a GoFundMe for your children. You have to put your children first. Do you understand?
Yes, ma'am.
All right, good luck to you.
Thank you.
7-0-0-0, State versus Richard D. Wallace. Can I have parties announced for the record for the state? For the defense?
Michael Collins, attorney for defendant, present and ready.
And are you Mr. Wallace? All right, let's start off with the plea paperwork and with the judgment. There were some corrections that needed to be made to the judgment. Mr. Wallace, I know that your attorney has explained this to you. Is that correct?
Yes, Judge.
All right. But I'm going to put it on the record to make sure that everyone is on the same page. So in the judgment, this is listed as an assault, family choking, strangulation. However, the offense of your the offense for which you were convicted is going to be assault, intentionally or reckless breathing to stop circulation, family violence with a previous family violence conviction. Is there any objection from either party to changing the current judgment to that convictions, to that offense? State,
No.
defense.
No objection, Your Honor.
And the code section is going to be 22.01 of the Texas Penal Code. Any objection to that being the statute for the offense? State, defense.
No, Your Honor.
Mr. Wallace, do you have any objection to anything that the court has placed on the record so far? Now, with regards to punishment and place of confinement, it's going to be corrected to show that it's 6 years TDCJID and a fine of $1,500, imprisonment, institutional division. Any objection? State.
No, Your Honor.
Defense, any objection?
No, Your Honor.
Mr. Wallace, any objection? Any objection to the court signing the judgment non pro tunc as with those corrections? State. Defense.
No, Your Honor.
The court then is signing the order, and if either party needs a copy, the clerk will prepare a copy so that you all may have it. Next, we're going to proceed. Now the court is going to proceed with the motions to revoke. Mr. Wallace, did you review the document entitled Motion to Revoke Community Supervision, First Amended Motion to Revoke Community Supervision, and Second Amended Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Richard D. Wallace who was placed on community supervision in 2018 CR 7000 for the offense of assault, intentionally or reckless breathing, circulation, family, with a previous conviction on December 17, 2018 for a term of 7 years? Is that you?
Yes, ma'am.
State?
Yes, Your Honor, on the Second Amendment motion to revoke, violating condition number 1, on or about the 20th day of June 2024, Bear County, Texas, the defendant, Richard D. Wallace, committed the offense of possession of controlled substance violation of condition.
All right. To that offense, how do you plea? True or not true?
True.
State?
Your Honor, we'll waive any violation.
Any objections to the state's waivers?
No, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 6 years in prison
Yes, Your Honor.
and up to a $1,500 fine?
Yes, Your Honor.
Counsel, for your client
Yes,
and state. Knowing this, do you still wish to plead true to violation of condition number 1?
Sure.
Court will find violation of condition number 1 true. Is there a proposed agreement?
Or, however, the state is TIC taking consideration 3 different cases. County Court 14 case number 722471, and that's a theft case, and then also a possession of controlled substance case as 2024 PF 04139, which we have pled true to, and that's a possession case, and another possession case of 2024 PF 04140. And Your Honor, the state is recommending revocation.
All right. And defense, what are you requesting?
Your Honor, my client was put on, it's a 7-year length of probation back on December 17th, 2018. Shortly thereafter, starting April 11th, 2019, he was sent to safety. He completed safety, did 186 days in safety, Your Honor, completing it on October 14th, 2019. Beginning on October 14th, 2019, he was then sent to residential aftercare, which he did for 60 days, Your Honor, completing that on December 13th, 2019. Beginning on December 13th, 2019, and ending on August 18th, 2020, my client did set safety outpatient aftercare, Your Honor. If you look at his the motion to revoke, Your Honor, or the court summary, he was testing clean for a long time, Your Honor. He tested clean from December 17th, 2019 until July 23rd, 21. We did have one positive during that time period, Your Honor, 19 months. Right after that, my client, he hooked up with some lady that he knew or met. She was heavily into drugs. He relapsed, Your Honor. And as you see on the testing after that, it went downhill, Your Honor. Started testing positive, failed to submit, all those kind of things until.
Was her name Eve?
What's her name?
Janelle.
All right, I always say, was her name Eve? Because,
Oh, the temptation.
Yes.
Yes.
that's, we
Not this
blame
time.
women
Not this time, Your Honor.
for leading us astray.
No, he realizes he made a mistake in being with her and relapsing. Your Honor. What we're asking for, Your Honor, he realizes he has a problem here with the drugs, Your Honor. He'd like, safety did him good, Your Honor. He came out, he was doing fine. He'd like another chance. I believe in talking to the probation officer, there is another, like a relapse program or something like that they have through safety or something similar to that. And he's more than willing to want to get into that program and get himself some help, Your Honor. He still, of course, has until December of 25 at this point, if the court does not extend his probation. But of course, if the court extends it, he would have still a lot more time on probation.
All right, probation. What is probation's recommendation? All right. So is there anything you wish to say, Mr. Wallace?
Yes, ma'am, Judge.
All right, you can raise your right hand. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Richard D. Wallace.
All right, what would you like to say?
Just want to say, Judge, that come before you today that when I got out of prison, I did 9.5 years of a 10-year sentence. And that was 2017 when I was released. When I was released, I only stayed out. I came out with 6 months parole. And I came back to jail in 4 months. When I came back in 4 months, that's when I picked up that charge, the choke and strangulation. It's given a chance since it's AP. It did me some good. I did everything in my willpower to promise my family that I was going to succeed and finish this probation successfully because I had a courtroom full of family support. And I understand that I met somebody. I got with somebody as soon as I got out. I got with a good woman and she helped me save money. I was working. I was doing everything. But I happened to relapse. And then from there.
Well, let's back up a minute. The good woman you were with.
Yes, ma'am.
Is that the same woman who led you astray?
No.
So you preferred someone to lead you astray over to the good woman who was there for you always.
Yes, ma'am.
All right, you can continue.
And well, she tried to tell me to stop doing the drugs, but I was already too hooked on drugs that's all I really cared about. And she got tired of it. She kicked me out. I went back to my mom's. I hooked up with this girl. And then from there, I just drowned myself in drugs. And after that, Your Honor, I relapsed. And I was already, when I was going to probation, I was already in process. When I was coming out dirty, my probation officer had told me, well, I'm waiting for the courts to send me back on what they're going to do with you. So on that same day, that was a Wednesday, and 2 days later, I had a warrant put out for me. And that same day, I get a phone call. Well, that same day, I get locked up. I come to jail. I post bond because I was trying to get out before the MTR. So I get out. But this woman that I was with, Your Honor, and I'm just telling you the truth, man, it was over drugs. I didn't take her to the dope possible score. So we went to
oh no, here's the thing. Let me just tell you, the state didn't go over any of those allegations. They weighed them. So the only thing we're dealing with is your probation being violated because you were in possession of drugs.
And I mean, I just wanted to let you know how it went because it's the truth. And after that happened, came to jail, posted bond. The woman lied on me and said that I had hit her. She knew my rap sheet. I never touched the woman. Never. So after that happened, I posted bond. And 2 days later, when I posted bond, Monday, my probation calls me and asks me, she's like, how were you released if you're supposed to turn yourself in to Safe P because you were going to go back? I said, ma'am, I never turned myself in, picked up another charge. So from there, she had said, well, let me call you back. Well, from then, my phone died out and I never heard nothing. So I just left it like that. So I stayed on the run for a year. And that's just the truth, Your Honor. The only thing is that I'm asking you is that my life and my future is in your hands, you know? And all I'm asking is a chance. I'm coming to you for help so you can help me so I could successfully complete this probation. And I'm asking you that it's you that has the authority, the control, the power, that either you could help me, send me back to prison, or you can release me. And if it's in your will, to put me in an outpatient or rehab, and I'm willing to do whatever the stipulations that you want to give me, I'm willing to do. And I leave it to you, Your Honor. And just for the record, I just didn't feel that with the VA, I tried to explain this, but I didn't have the chance. So I said, you know what, I'll just put my life into your hands and I'll let you decide.
Okay. Any questions, defense? State, any questions? All right.
Could I have those printed out pages, please?
All right, the court is finding violation of condition number 1 true. I want you to know that I always listen, and people who come before me, I see every person who comes before me as a human being. I don't see people as criminals. That is why normally I will call people the accused, because that's what they are. I try to stay away from calling people defendants and giving anybody, be it for the state or the defense, certain labels, because I think once you start giving those labels, then your mind switches to a different place. So I see you as an accused person. And I understand that there's been help for you. And the reason, when you're sent to safety and other places, I know that once you successfully complete safety, they place you in outpatient treatment. And when those things are done, you've been given the tools to stay clean and sober. And those tools are calling your sponsor, calling your probation officer and saying, hey, I'm back in the throes of my addiction. Can you help me? And both the state and the defense know that people who are placed on probation with me, normally, if it's an addiction issue for them personally, they're not picking up new charges. They are not hurting other people. They're hurting themselves. I will usually try to work with you and get you to an inpatient treatment. And if people don't want it, they don't want it. We can say, I tried, the state tried, the council tried. All right. Your case is something that's completely different. So I'm going to find number 1 true, take in consideration county court cause number 1470. I'm going to give you credit for the time that was successfully completed in inpatient treatment, not the aftercare portion, just inpatient at safety. And of course, give you credit for any time served, which the court must do. There's a $1,500 fine. Time and money will run concurrent. I'm going to revoke you. I'll suggest the therapeutic community. You'll have to sign up for it. I have no jurisdiction to have you placed in that program. That program doesn't increase the length of time that you're in custody, but hopefully it will help you with your addictions. When you're released from prison, if you can't find a place for inpatient treatment, if you come back here, I will call around to make sure you get in place at an inpatient treatment facility. Does anyone wish to speak to length?
Yes, Judge, I mean, considering that it was suggested Saturday before yesterday, state's requested 6 years.
All right, defense.
Your Honor, in light of my client having gone through inpatient programs, outpatient programs, aftercare programs, Your Honor, and coming to the court and explaining that he still has problems with drugs, being very forthright to the court, we'd ask that the sentence be closer to 2 years, Your Honor.
All right, the court will sentence you to 6 years in prison. Is there anything else with regards from sentencing for either side? All right. Did you review the state, you may be excused. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is not a plea bargain agreement. You do have a limited right to appeal. That right to appeal is that it relates to the allegations in the motion, not the fact that you were on community supervision. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, good luck to you. I wish nothing but the best for you, okay? All right, thank you.
Your Honor, and of course, over and above the residential, the inpatient treatment that he got, days credit that he got, of course, he's going to be getting all credit that he has been spent in custody.
Yes, you'll receive credit for the time that you've been in custody and also credit for anytime in inpatient treatment.
Same.